Hi, thank you for joining us. Welcome to the Titan York Show. And we're here today. We're just waiting for Dan Bank, I think, to come on board. But oh, here he is. Hi, Dan. How are you?
Good. How are you? Thanks for having me.
Oh no, thanks for joining me. You're going to help me and a lot of people out today get some clarity because we're just getting a lot of calls and we're giving people commercial brokerage advice. And I think there's some deep legal questions that are coming up. And I know you can't answer specifically for for every specific person on here, your advice is in general. But Dan Bank is a lawyer and he is give me a second here, there you go. You're a lawyer with Rose, Persiko, Rakowsky, Melvin. But Dan and I've been working with Dan for many years, and I've referred many tenants to him to help with their leases. And maybe you just tell a little brief something about yourself, and I'll go on about myself, and then we'll move on.
Great. Thanks, Aaron. Thanks for having me. Yeah. As you mentioned, I've been practicing. I'm a partner with Rose, Persiko, Rakowsky, Melvin, LLP. And I've been practicing for over 10 years, working with small businesses and entrepreneurs, and have extensive experience on working for both landlords and tenants on all leasing issues.
Yeah, I can tell you that you're an entrepreneur-friendly lawyer for sure. That is, you're definitely one of those people that if you have a small to medium-sized, mid-sized business, that you're someone that's a generalist that can really help out, and at the same time a focus on real estate. So I will definitely say you're a great resource for anyone. I'm Aaron Graben. I'm the president of Titan York. I've been around for 21 years, represented a multitude of number of tenants across the GTA, both in office and retail and investment. And I'm going to sort of talk about what we're going to talk about, the topics, and then we'll get right into it with Dan. And that I did add something to the end of this that wasn't originally on here, the Canada Emergency Commercial Rent Assistance Program for small businesses. And that is something that I know a lot of people are asking about. So we'll get to that at the end. But first we'll talk about COVID-19 a little bit. Default is one of those questions that come up. Tenants are claiming force majeure, acquiring enjoyment. Why won't insurance cover things off for me in these tough times? And what are the effects? Like, what's going to happen if I do defer rent? What can the landlord do to me? And there's a reality versus the leases, and many, and we're going to talk about that, like what's happening and how that's affecting leases. So I'm going to start off, and I'm going to let Dan do most of the talking after this. But to start this off, there's a commercial real estate ecosystem. So there's lenders to landlords, landlords to tenants, and tenants get their money from consumers. The consumers have unprecedentedly disappeared, and it is affecting that whole ecosystem of how who feeds off of who and how money gets moved. And it's created this paradigm. So a couple things on the paradigm. First one was that we roughly stopped working around the same time, and we're roughly going to need money around the same time, and hopefully there's going to be money there to help us. And the government's doing a great job, I think, of making sure that we're going to be caught as we fall. We're frozen in our geography, and we're frozen in our real estate. We can't outrun the COVID-19. We can't go to the US. We can't go to Britain. We can't go to Stouffville. I can't go to Barrie, like wherever you go. And that is worldwide. If you're in Shanghai, you have the same problem as I have in Toronto. And that's created a very interesting environment for leasing. So if you can't outrun your faltering economy, the space that you have today is all that you've got. And inversely, as we come out of this, we're all coming out of it together. We're all going to need help together. So our leases are really becoming more and more important every single day as we get towards moving out of this. And that's it. That's all you get. So people are focused on what that means, running out of money, but we still want to keep our leases. And I'm going to just move this right on to the first question that is in everyone's minds: default. So maybe we can talk about that and material versus non-material. And Dan, talk about default if you can.
Sure. So there are at a high level, two general types of defaults. There's a material default and a non-material default. A non-material default are simple things that are corrective. You have a leak in your kitchenette. You've got a hole in your wall. You haven't been you haven't been at the office you're not there 365 days a year. In those situations, you'll see in leases it says that the landlord will provide notice, and you have a period of time to cure that or commence to cure those defaults. A material default are typically monetary or fatal, and failing to pay rent would be one of those. There's much less leniency for those sort of cure periods, and it could result in the termination of your lease.
Okay, so what happens if I pay a part of my rent? Like I can't pay it all.
Right.
Landlord hasn't agreed to any negotiation, and I just say, you know what? Here's 50%.
Right. So under the terms of the lease, and we're going to talk, this is going to be a theme throughout this discussion that we're having. There's what we have in the lease, the four corners of the contract, outside of like in a vacuum, and the realities of where we are today. You are in default of your lease if you do not pay 100% of what is owed under the lease on time, at the appropriate time, bi-weekly, bi-monthly, twice a month, once a month, whatever it is. And so under the letter of the law, if you pay partial rent, you were still in default and could be grounds for termination.
Yeah.
So that's in the strictest terms.
What if my landlord says, and this is one that came up recently. What if the landlord says, you know what, just pay me 50%?
Right. So okay. So let's get into the more interesting.
Landlord says, let me pay 50%, and he just says it verbally. You pay 50%.
Yes. Yeah. So in that, I mean, I would give in that scenario, I would give practical advice to say, like, well, try to confirm it in an email. But if I would pay half the rent and better than paying the full rent. I don't think it would be reasonable. Okay. Let me just state, given where we are in the reality of COVID, there is an expectation, I think, on both sides, and a practical reality that both sides have to come to act reasonably with these things. I would definitely, my first piece of advice, we call it legal advice, is don't do anything unilaterally. Don't think that you've read the contract and you think, well, there's a force majeure clause that says an act of God, COVID qualifies as an act of God. I'm not paying rent, and that's it. Or the landlord has locked me out because the building's been locked out, and therefore I'm not paying rent. And I'm not talking to anybody or doing anything. That would be a mistake. And we could just jump into that maybe for a second. So as you've pointed out here, we've got a force majeure clause. And a force majeure, there are certain clauses that seem to be bubbling up as points of contention for grounds to either enforce or not enforce these obligations, one of which is a force majeure clause. So typically a force majeure is when there's a major event that happens, so war, act of God, or other reason beyond the control of the party that's delayed, so that if you're frustrated, if there's a bona fide reason why one's efforts to carry out an obligation on the lease are frustrated, then they are excused from doing it until such time as that hindrance is no longer there. The challenge with raising that as a point is, the drafters of these have come over like literally hundreds of years of case law and contract law. We've come to these terms, really never contemplated, global pandemic. And so there's without an express, wording of a global pandemic, or very specific language, this isn't the magic bullet that many people think it may be. Listen, it may end up becoming the magic bullet, but it's going to only be it doesn't help the tenant now who's trying to convince the landlord that he shouldn't pay rent, because he's going to say, well, force majeure applies, and the landlord's going to say, no, it doesn't. And there hasn't been enough case law on this point specifically about a pandemic. By the way, the courts are all closed right now, so that doesn't help you. May 1st is coming up. Should I pay rent or should I not pay rent? So I would not be using the force majeure clause on real, grounds to just say, well, unilaterally, I'm going to not pay rent.
Dan, just a quick thing. I think I can hear you. Everyone can hear you. Move a little bit back, just your head, just so because it cuts in and out a little bit. But
okay.
It's great. So yeah, I mean, this is one of the conversations. I'm a tenant in a mall. I'm in Yorkdale. I don't know, name a tenant, and the doors are locked. The government is, and I can't access my space, and therefore you've stopped me from entering the building. So is that force majeure or is that quiet enjoyment?
Yeah, so maybe if you go to the quiet, I pulled a clause there about quiet enjoyment. Yeah, so quiet enjoyment is the concept that if you, as long as I haven't done anything wrong, landlord, and I'm paid my rent and I'm not in default, you can't interfere with my ability to enjoy the lease and operate my business. You, the landlord, have now, taking this to the logical conclusion of the argument, you, landlord, have prevented me from entering my premises. I would have otherwise, wanted to, and therefore you're in default of the lease and I don't have to pay it, or I can get out of the lease. And again, similar, maybe that will work if, in a year from now when both sides are in court and everyone will have their day in court to make those arguments and case law will come out of it. But, the landlord is going to say yes and the tenant is going to say no. And, again, we're sort of left with a very real practical solution, problem, quagmire. Is like, what do we do? The landlord would say, well, the government has made me close. I didn't want to close. I would love you to be for the store to be open. I just can't. And therefore you still have to continue to pay rent.
So, okay. So that was the one you and I were talking about yesterday, and I was going back and forth with you about it. I was like, if I'm a tenant, and I get it, like, listen, everyone's in a really bad position in this whole process. There's no goodness coming out of it from the perspective of where we are in the short term. So I can't, everyone's asking me for advice, and I'm saying, the lawyers are telling me force majeure is something you can't use. Quiet enjoyment is something you can't use. And then I've had people say, well, I've been paying business interruption insurance. Doesn't that cover it? And,
right.
and can you sort of give us something on that one?
Yeah. So business interruption would probably be the third point, as you noted. And traditionally, that business insurance is meant to cover when there's been a loss of business as a result of physical damage, okay? Giant fire, an earthquake, a collapsed wall of some sort or a ceiling or something like that. And traditionally, insurance providers have not paid out on that. There's been a court case that's come out just recently, MDS, the Factory Mutual Insurance Company. I'm just looking it's a long name. A recent court case has come out, which hints, it doesn't specifically talk about COVID because it just didn't, but it hints that there's an expansion of the physical damage concept to include COVID. So there is a movement now. It's going through the courts. It's going very slowly, but the idea, so we don't know definitively what the results of it are going to be and if this will be a groundswell solution. But it is definitely something that I would explore with my insurance broker to get their opinions on. And the way it may play out is you just apply for business interruption insurance and see what the insurance companies say. And if they say no, then you can contemplate the strength or merits of suing that insurance company to say, no, a new court case came out and you didn't consider this, that, or the other, and you have to pay. But we don't know definitively, and I don't know if that helps you May 1st for rent, unfortunately.
Yeah, I think that's probably, whatever And that's your theme. I mean, the theme is it
Yeah.
doesn't matter what advice you give. People are going to take immediate action now,
Yeah.
and the
Listen, yeah.
cost will put it in the distance.
Yeah. The reality is this, look, on both sides of this, okay? And you'll speak more to this, but pre-COVID, we were in Toronto at less than 1% occupancy rate, $40 a square foot for rent. Impossible to find anything anywhere. So if it was just, everything was in the landlord's favor. I don't think that we're in that that's just on the ground. That's not the reality anymore. And certainly not right now. And I don't think for quite some time afterwards. I think that even when we go back to work, it will be on a very gradual basis, and people are getting used to working remotely. Companies are getting used to working remotely. I don't need the same square footage that I used to, whatever. And so, from the landlord's perspective, if a landlord, and when a landlord comes to me and says, my tenant's not paying anything, the reality is, okay, well, so if you kick them out, what are you going to do? Are you better off with a tenant who previous to this was a fantastic tenant, paid rent on time, and you're going to kick them out? Now you're going to have to, who's going to replace that person, right? Today, so rather than do that, why don't we try to find a solution? I've got some great clients who are tenants in restaurants, and have put a ton of money into these properties, tons of money into these properties, and there's these property owners, they're meant for restaurants. So what are you going to do? You're going to kick these great A1 clients who operate a great restaurant out for some variable down the line? So no, we came up with a rent deferral, and in some cases a full rent abatement for the next 6 months, which just gives everybody a balance, a pause to just, or a lifeline to just hold on until we can come back. And I would say that is the approach, whether I'm dealing with a tenant or a landlord. Reasonable people will come to a reasonable solution, hopefully. And that's certainly the attitude I take with my clients, whether it's on the tenant or landlord side. Like, look, we're going to have to find a solution, because if we don't, you're going to be tied up in courts, which can't hear you, by the way. The courts are closed right now. I mean, on an emergency basis, they're doing it remotely. But day to day, everything is pretty much shut down. So how else are you going to find a resolution other than just coming to the table and finding something that works?
No, I can tell you, like, as one of your strengths. So I've been your client too over time too. One of your strengths is that you look for a reasonable spot where both opponents can get to a solution that makes sense. And specifically in this time, I think that is really the message that is that putting yourself forward as a service provider, that's a huge asset, Dan. And you're right. This whole thing that you talked about is there's it's the four corners of the contract versus what's happening in the reality, and in the end it'll be somewhere in the middle. And if someone wants to hold to the four corners of the contract, you might have some vacant space.
Not only would you have vacant space, I think there's a general sentiment. There's a phrase my litigation colleagues always coach me up and says, your clients have to come to the court with clean hands. Okay, what that means is you have to have done everything honestly and in good faith to try to come to a solution, right? And we're going to get to it with this rent relief program and other things, but so again, let's pick on the landlord as in my little example. So you have a 2-year lease, okay, and the tenant is defaulted under the lease. And so typically if they don't pay, then the landlord has, as part of its judgment, there's lost income for 2 years, which the tenant could be on the hook for because he signed a 2-year lease and now the tenant is out of pocket. But the landlord has an equal responsibility. He has a duty to mitigate. He's got to try to relet the premises to limit his damages and exposure, right? And if he hadn't come, so this works both ways, both for the landlord and the tenant to come with clean hands. But if the tenant had done if the landlord had done everything in its power and the tenant was just unilaterally messing things up and saying, yeah, screw it, I'm just going to not pay rent, then maybe the courts would say, you know what, you're fully exposed to the full 2 years of rent because, and that's it. But if both sides came to a compromise or were shown to have tried to find a resolution, I think the courts would look and say, well, 2 years, we're going to cut that down to 7 months exposure. And that would be that. So there is a sense of reasonableness, I think, both practically, like as a commercial lawyer, I would say, but even within the courts, I anticipate that that's going to be the rule of law going forward.
So I'm going to go back a couple of slides just really quick. We're not going to talk about it, but I'm just going to say, like, look, force majeure, quiet enjoyment, so your ability to actually, use the premises, business interruption. Like, I got a feeling this will be in the courts a lot over the next 2 to 3 years, and that'll be one of the ramifications of COVID-19. Okay, so if I defer rent, if I go, yeah, let's defer rent, do I lose my other rights under the lease?
Well, maybe, right? But I if you have a good lawyer, I would say that as part of the negotiation of deferring rent, it comes.
Oh, we're losing you there, Dan. Okay, we lost him.
On paper, no future obligation. The future rights are there. Can you hear me?
Yeah, just you cut out for a second, but I think what you're saying is, if you do get a deferral of rent, in your documents, you should say that all other rights and terms of your lease should stay the same. I think it's something that
yes, you would want to try to do that. But if you don't, if otherwise, to finish the point, based on the contract itself, as I say, the four corners of the contract, if there's a default, even if you've cured it, that could be grounds to lose your ability to have your lease renewed.
Right. So if you do default, you may lose your renewal right. And I think look, everyone's in such a rush for a deferral, and to get that money, you forget, what else is there. And I understand that, like, getting a deferral right now is a very important thing for a lot of companies, because it's not that they can't always not pay the rent today, but if the financial paradigm of COVID-19 plays out, by the time we open our doors, it's still going to take 3 months to get things going again. And in that, so 3 months down, 3 months up, which is ironic because it's kind of what I said back in March, but 3 months down, 3 months up. And then, so anything you can defer today is cash that you can use later on to open up and get going. And we're in such a rush for that we're forgetting about all the other clauses in the lease that we're going to let go of just to get our deferral. So I think it's important that as you're agreeing with your landlord, that you also ensure that there's a deferral from that perspective. That the
rights are still preserved. Yes.
Still preserved. So I got to tell you, like, my email is a buzz in this, and we'll get to questions in a bit, but the Canada Emergency Commercial Rent Assistance Program for small business. So I'm going to start by saying that neither one of us is an expert on this. I'm not sure who's an expert in it, but if you want to know all about it, what you do is you go on the Canada Mortgage and Housing Corporation website, and there's the if you want to write it down, or we'll send it out. If you go to that link, you will be able to, it'll give you all the information that I'm about to show you. So I didn't write anything that's following this. This is literally me copying from the website and putting it forward on here. And but you can sign up for a newsletter or to get any updates. So you'll get an update as soon as anything happens. But it sounds like it's going to be brought out in the middle of May. And this is basically what it is. The government the tenant will pay 25%. The landlord, the government will pay 50%, and the landlord will not take in the other 25%. And one of the questions coming back is that, and I'm a big proponent of rent deferral, not rent abatement. And that's effectively a rent abatement. So what I'm trying to understand is that if we agree to this, if the landlord's like, okay, no problem, if the landlords agree to it and the tenants agree to it, is there a place where the landlord could say to the tenant, yeah, but you owe me 25% later on? And that was one of my questions. I don't know if you have the answer for this, because this is like fresh. It was really, really fresh. Maybe you want to talk about what's going on and before I go to the next slide from your perspective on this rent relief for tenants and landlords.
Sure. Again, this is all happening in real time, so please, viewers, don't hold this really against me. But from everything that it seems to be that they're not mutually exclusive. You can apply for this program and be under this regime and still work within a separate. If you had this is, as you say, this is a rent abatement, but you could still have a rent deferral or some other agreement, and nothing precludes one from the other. Critics of this program will show was a great memo that came out by the Royal Bank of Canada on this program, and they note that. So I'm just going to read off a couple key requirements here. So the tenant must pay less than $50,000 per month in rent. Okay, that's a big one. That's probably easy to do. They have to have ceased their operations, and they have to have had a 70% decrease in revenue. Okay, and so that's the first part. The second component of this is that it's the landlord who is applying for the loan first. Okay, and then for an amount equal to 50% of the tenant's rent for April, May, June, and then it'll be forgiven if they then reduce the tenant's rent by 75%. That's the way it works. Okay, and the tenant has to have qualified for those things. So again, $50,000 per month, ceased operations, and has seen over 70% decrease in revenue. The challenge is, that takes a lot of good faith and coordination between the landlord and tenant. It's almost as if they have to work and apply together, because the landlord has to know and have verifiable proof. I'm not going to take this massive loan.
Oh, Dan, Sam. Sorry. I'm going to mute him for a second. Nope. Oh, there he goes. Okay.
My sound?
Oh, there you go. Dan, you're back?
Yeah, I'm sorry. Can you hear me?
Yeah, I can hear you. You're back.
All right. I'm sorry, everybody. What I was saying is,
you know what it is, Dan? It's your kids downstairs using all the internet.
I know they're watching Paw Patrol. What can I tell you? What I was saying though is that this program involves the coordination of both the landlord and tenant together, because it's going to rely, if the landlord is going to apply and take on this loan, which is a hefty loan equal to 3 months rent, they've got to be sure that and very confident that the tenant's revenue actually has been decreased by 70%. So there is an administrative burden to this, and so that's one of the several critiques that industry experts have noted here. But we'll wait and see. It's definitely an option, and hopefully it's a good one. The other thing, which I'm sure both tenants and landlords would say, is, well, I don't know if this is enough money. I don't know if this is enough. Like 3 months is nice, but as you say, even if we're back to work in June, what's the ramp up period to get back to business? Where I may need till December before I'm locked and loaded, ready to work. So that's where we are with it.
Yeah, I'm not going to go in, only because everybody can read it on their own and go through it and I think what's going to end up happening is we're going to figure it out as we get into it. So we'll say to the tenant, so the tenant will say to the landlord will say to the tenant, okay, let's do this. Like, for example, a yoga studio, like that's it. They've got no income. They've been shut down since March 16th. There's no way this guy's getting revenue, and the landlord is there's just no chance of it going forward. And the chances are that as a yoga studio coming back out of it, I mean, there's a question of, do people actually want to go to a yoga studio and be around other people? So there really will be a ramp up in time. I think that's a no-brainer. I think that there's other businesses, specifically that I think more of a challenge for that 70% decline will be in the office market in terms of, is there a, for example, I'm a real estate brokerage and I get paid a revenue today from deals that I did 5-6 months ago. And, but I'm not doing any deals today. So that means I'm not going to get paid in 6 months from now. So, it's really not, I think that's one of the challenges. You're right. How does the tenant prove that they're down? And I think that'll be an interesting conversation. I'm going to move you on to, I'm going to just do a takeaway from this actually, before we move on. What my takeaway from this is that there's a contract, it's signed by both sides, and a contract is a contract. And, even in unprecedented times, that contract is still valid, unless you can prove otherwise. But there is a reality, and the reality is, if there's no more money, it's default. And I think that's really kind of that level of, the landlords don't want to lose their buildings to the lenders, and the tenants don't want to give all the money to the landlords and not have a business left and have to go bankrupt. So there is this definite sophisticated conversation that's happening between tenants, landlords, lenders, and now government. And that's my takeaway from this. That this is, there's no, you can't give anyone, you can't tell someone to go into default. And I would never tell anyone to do that. But there's a reality that there's no more money, they're going to go in default, and that's it.
Yeah.
I'm going to put out some questions here. Well, questions. We have got 61 participants. Wow. Jason Tan says that I'm wearing a nice suit. Thanks, Jason. How do you define small to medium size square footage and staff? I think that's kind of the question, is what's small, what's large? Like, where's the cutoff? I think it's a revenue model. I think it's the size in terms of the breadth of the company. I mean, I know U.S. companies who are massive billion-dollar companies that have 5 people in Toronto. So, and that's a good question. And it's a Canadian division separated. So I think there's lots of stuff on the side. Here's one. What about tenants that are either have not taken possession and begun fixturing, or have taken possession within the last few months, but can't complete construction, so they can't open per the terms of the lease, or can't open because the government won't allow them to, at least for now? How does that affect their lease and eligibility for the CECRA?
A lot packed in there, but the first thing I would say is, as you know, Aaron, there's there should, if the lease was drafted correctly, there's hopefully there's a concept of a day-for-day extension on, during the fixturing period until such time as you can take occupancy. And so if you can't take occupancy, like everything, would just be on hold.
So occupancy delay.
Yeah, I think so. I think that would be the first thing I would look at and consider. How does that affect their lease and eligibility for the CECR? I'd have to really turn my mind to it. But these are the types of gray area questions that, I wish I had a clean answer for, but that would be that.
I think there was an answer for that. I think that they had to be receiving rent in 2019.
Mm-hmm.
I think that was one of the, and I can go back to it later on, but if you go onto the website for CMHC and Canadian Mortgage Housing Corporation, I think that will affect their eligibility. So, and then I guess the conversation is, was the lease signed in 2019? We're going to have a lot of fun with this one. Okay. If I have more than one office and I can only afford to pay rent from one of them in May, would the landlords ever communicate with each other? cannot paying rent at one affect my tenancy at the other? You know, I think I'm going to answer that one and I'd probably say no. I mean, you have separate deals and separate contracts with separate people. Two are not connected. But I don't know if Dan will back me up on that one.
Yeah, no, they're separate. They're separate. There's no like landlord, chat room, where they're talking to one another in that way. The only thing I would say is if you were sued, your company was sued, and there's a suit came up, if anybody did a corporate search on you or a litigation search, it could come up there was a claim, or if you were a personal guarantor on a lease, and you were sued on it, that would affect your credit. So those sorts of things. But as like on a pure, they don't speak to one another. They're different companies.
What will qualify as gross rent? Example, do food courts costs qualify? Do franchisees who own a business but do not hold the head lease qualify? If leases are held by a leasing company, not the operating company, does that pose an issue as it operating? Well, I guess that's a conversation, yeah, like, franchise, subleasing. I don't think it addressed that in terms of the sublease. So you would literally, that's a really good question. If I'm a subtenant and I want to go for rent deferral under this program, I have to go to my sub landlord, and then the sub landlord is actually the one that has to go to the head landlord, and the head landlord has to agree to it. But the head landlord says, well, why should I agree to it? I've got 2 covenants under the lease. So no, pay your rent. And that's another layer to it that I think is coming up. And the other one is that what is gross rent? Percentage rent.
Yeah.
Does that on a retail tenancy, where does percentage rent come into it? And so that's a really those are all good questions. Of course, I have no answer. I have all the questions in the world, Dan.
Yeah, no, listen, it's an excellent question. It's a really nuanced question. Ben, if you want to give me a call, we can work through some of those through with those with you. But there, it's an example of one where it highlights the complexities of what we're talking about. I mean, with head landlords and sub landlords, and for when it comes to percentage rent, I would say, well, if the percentage rent is 0, you're out of luck for the landlord. But mind you, it's interesting. I'm literally negotiating right now as a compromise for when we get back into, to next year. We're moving away from a base rent to a percentage rent, because the tenant will say, listen, I'm happy to pay, but I need to know that there's a business here before I can pay rent, and I'll even give more than I otherwise would have, but I want the assurance, like if it's 0, then I'm not going to pay rent, and if it's,
that's really smart.
Yeah.
To say, look, like I don't know if I'm going to
let's take the risk together,
Yeah.
And there's upside for you, landlord, for doing so. So working through some of those things.
That's really a smart solution. I mean, it's not going to be good for landlords. Aren't going to be like, I don't love that. My lender's not going to like that. But when things are dire, I don't know.
Yeah.
My business conditions qualify. Oh, sorry. Is the 75% revenue threshold calculated at the property or corporation level? I think it's 75% of the rent, not of the revenue. So basically, if I'm paying $10,000 a year, I'm going to get 50% from. If I'm the landlord and I'm getting $10,000 a year, normally I get 50,000. I get 5,000 from the government, and I would get 2,500 from you. And that would be it. I would have to suck back 2,500 as a landlord, I guess. But again, that goes to that deferral question. My business condition qualifies for CECRA subsidy, but it seems the guidelines are still unclear regarding my next steps or not paying May rent or for going forward subsidies. Okay, so my recommendation is that my recommendation is pay your May rent. Even if you have a deal with your landlord to pay 50% rent, pay your 50% May rent, and then let it come. According to the thing, the landlord either has to rebate you that other 25% in the future, or they give it, or they give you 25% in the, like, they'll give you the 25% back, or it'll be applied in the future. So I really think you, I really think you should pay your rent if you value your space. I'm not a proponent for not paying rent unless you really can't, and finding a way, because it is an ecosystem. Like, we're all in it together, and if you can't pay it all, pay something, talk to your landlord, and that's really where you got to go. Assuming you come to an agreement with your landlord on mutually agreed terms to continue the lease, can you still fight with your insurer for disruption coverage? That was your advice to me, was, so Dan, tell them that I'm not going to tell them your advice. You tell your advice.
I don't, yeah. Well, for this situation, what I would say is, again, you have to show actual damages, right? So I think, Aaron, what you're referring to is, again, just trying to do on the business interruption, what I was talking about. But first things first, settle with landlord, right? And then you would make a claim for the insurance. Your settlement may be affected by, you can't be found to be unjustly enriched, which means getting more of a reward than you would have otherwise gotten. So if you came to a compromise, but the insurance should, pay the difference if it was a successful claim, but you wouldn't expect it to get 100% of it back if you've already made a compromise with the land.
I have one here that was actually emailed to me. We rent in a large building with mixed use units, from residential to retail to some wood shops, etc. When I spoke to the landlord, he said that his whole building was industrial, not commercial, and so the rent program does not apply to his building. We, like many tenants, are renting there as simply office space for our businesses. What's the story? Thanks. By the way, I know the building, super cool space. And I won't say it out loud, but I think they have not specified the type of real estate, right, Dan?
No, they have not.
So him saying, I think he's using the, I think he's either wrong, or he's, positioning himself for a conversation of no. So I think that's one of those things out there that you should be looking at. Okay, here's one more. While I understand every case is different, and this would never be a lawyer's piece of advice, how often are landlords successful, maybe as a percentage, at chasing a smaller entrepreneurial-based business for not paying the rent? Is there a number when it is actually worth it for them based on the value of the lease commitment versus the legal expense and the time to do so? By the way, this is from an agent that I know in the marketplace. So this is coming from another, not Titan York.
Yeah, well, I'm not, it's one of those things, litigation is expensive, and, they will have to weigh the pros and cons of doing so, and it's if you're the company, how easy is it for you to just, are you a shell company? Have there been guarantees on it? How easy is it? Could you just, if you were company ABC, how much goodwill have you put into the market under that name to just expand it and start a new company? So, there's practical concerns there. But if the person who asked the question is that entrepreneur, I'm not giving you advice to just ghost them and walk away in the middle of the night. But the question is, there's a calculation of, is it worth the risk, right? Or worth the cost to go after the person?
I'm going to keep going. We still got a lot more, people are really interested. So I'm just going to give you a couple more questions.
Okay. No problem.
This is from the chat. It says, I'm a landlord. I have a tenant who's due 3 months. I have a tenant who's 3 months past due before COVID. How can I collect the rent dues before COVID and now for the month of April and May 2020?
I'd look to the, I mean, in the abstract, like I'd look to the covenants under the lease, defaults pre-COVID. So firstly, there hasn't been a moratorium on eviction in the commercial space like there is in the residential space. So you have every right you had before at law to go after them in the covenants that they had, and certainly if these were defaults that happened prior to COVID, then they don't have the excuse, and the courts would probably be less lenient towards the tenant. But I'd look to the lease.
That's really interesting you should say that. So like a very big distinction, like as always, the residential tenancy acts do not apply to commercial. So
That's right. And it is much easier for a landlord. It's much friendlier for a landlord, as most people would know, versus a residential tenant. Good luck trying to kick them out. But on the commercial side, it's much easier.
I was just watching that there was a couple that had a nanny that didn't leave. I think they had a problem getting the nanny to leave because they're the landlord. Okay, yeah. Here's the next one. Since TMI costs will continue, do you think it is fair that under the CECRA, the landlord should consider the TMI as 100% due and pay and apply the CERCA term to the base rent only?
Yeah, so that's an interesting point. I don't think that the question is, does this apply? Thanks for bringing that up. There's a question as to what portion of rent can be deducted or not, if this is it base rent or additional rent, and if you have to pay the landlord, if the tenant was responsible for property taxes, for example, do those obligations fall by the wayside or not? And I don't think there's an answer yet on that. We're still looking
I think there is. I think I read it.
Okay.
That it applies to 100% of the rent. Okay, well, I'll get back to that one.
Okay.
It is. I think it does. But what's an interesting conversation is that what's going to happen with property taxes? Like right now, they're being deferred. I wonder what you're really deferring a good portion of that 25%, and I'd probably argue that 10 to 15% of it is probably property tax, which I think will be interesting to
yeah.
Okay, let's see what else we got here. Okay, let me just go in. Sorry, everyone. I wish I was more proficient at this. So, the landlord should consider TMI 100% due. Okay. I'll come back. I'm going to move on. If we can also add to that question, what if the business is facing bankruptcy, so their ability to collect anything is minimal? Okay, so go ahead.
Again, it's all circumstantial, but I mean, you're faced with the reality that you're in. If your company's if you're going bankrupt, then you're going to shore up your expenses, and in this market, where there's an opportunity to, where there's a softening of the demand for money for rent, then maybe you focus those limited resources to another area of the business to keep the business going, and the landlord would accept that because they want the tenant to be there in the future. But it's a very circumstantial question, but again, that would be there's a practical component to that. So
okay, I'm going to what I'm going to do is let me see if I missed anything. I don't think so. The questions are done. Okay, Dan, and I know that on the board the questions are moved to the left there. I apologize for not centering it properly. I want to thank you so much for your time. We are all in a place of trying to figure it out. And, the one thing that I've learned is that the ability to communicate calmly, nicely, without freaking anybody out has been such a reward in coming to solutions in this strange time. I have to be honest with you, when this first happened in March, I didn't know how relevant my profession would be in terms of the world where nobody needed space. But it turned out that that's not the case. It's quite the opposite. I spend most of my days from morning to night on the phone with clients, talking about what's coming up in their lease, what's happening with the landlords, what's going to happen with deferrals. And I can only imagine how much time you have, you've had to be on the phone yourself with your kids downstairs with Paw Patrol, dealing with what's going on. And I really want to thank you for taking the time to be here for all of us. I can attest, if anyone's interested in some great legal advice, Dan has a very unique mind, and I've always enjoyed working with him. So please give the guy a call. You can go back and look at this. It'll be up on YouTube under the Titan York channel if you want to go back to it, and we'll also send it back out again to everybody. But I want to thank you, and
Thanks. It was fun. Have me back.
Yeah, I will. Absolutely. Thanks for coming to the Titan York Show. Okay.
All right.
All right. We'll talk to you later. Everyone be safe. Have a great day.
Thanks a lot, guys.